Good afternoon. We're going to dive a bit further into the vast sea of data and how this data can and should be allowed to flow freely between countries. We have a fantastic panel of experts coming at us from different angles, and I hope we can all leave this session a little bit wiser about what the future holds for international data transfers. I'm Stephanie Bedoni from Bloomberg News, and this is the panel that we're going to have today. First up will be Bruno Gencarelli, who really has become the European Commission's Chief Data Protection Czar. That's my title for him, not his official title. And he is these days deeply engaged with just this question, how to best keep data flowing internationally, but in line with the EU's strict data protection rules. We will then hear from Barbara Cosgrove, Vice President and Chief Privacy Officer at Workday, who brings with her years of experience of managing international data protection compliance programs and with data governance policies and compliance standards that she has lots of experience with. Thomas Bouet, Director General at the Business Software Alliance, joins us to talk about what works and what doesn't work so well with data flows from the industry's perspective, followed by Vivian Arts, who brings with her years of experience as a legal practitioner and as a privacy counsel at several financial institutions, and now works at think tank, the Center for Information Policy Leadership. We'll also have the pleasure of hearing from the UK government via its Deputy Director for International Data Transfers, Joe Jones, and their latest plans on data flows. We'll start with a few introductory remarks. Bruno, first up, you are first up.
Well, first, thanks for having me here, and happy to be with you, Stephanie, and with my co-panelists. You ask us to kick off this panel by asking ourselves what the future holds for data flows, and you have asked us to be short. It's difficult to answer to this question by being short, but I think what the future holds, it's both. I think both. Indeed, there are complexities, there are new challenges, but there are also new opportunities and solutions. There are complexities, there are new challenges, and we'll discuss some of them probably during this panel regarding government access issues that have been identified by many countries, far from being only Europe, from Japan to the US as an issue when it comes to ensure a free and safe data flows. An organization such as the OECD is working on these issues right now. New challenges also probably around certain obstacles to digital trade and certain unjustified restrictions, but also new opportunities and new solutions. The actors and the possibilities that exist today when it comes to facilitate data flows are much more numerous and diverse than they were only a few years ago. And why I'm saying that very briefly, because there has been a very significant change in the recent years, and I'm referring to convergence that we're seeing in privacy standards around the world, in many areas of the world, countries as different as Brazil and Japan, Korea and Kenya. And when you see regulatory convergence, when you have regulatory convergence, that offers new opportunities to better protect data when it moves around, and it has to move around. Even our interaction today is based to some extent on data flows, and new opportunities to facilitate data flows, to better protect data and to facilitate data flows. Of course, it's much easier to speak, to negotiate, to build bridges with systems that share some basic common values and common safeguards. And that's why you have seen from our side the development, for instance, of our work on adequacy with partners as important as Japan. 2 years ago, we created the biggest area of safe and free data flows. And we're seeing these days, because we are about to adopt the adequacy decision, for instance, with respect to South Korea. The two adequacy decisions adopted with respect to the UK are a very important part of our post-Brexit relationship with the UK, and I'm sure we will come back to that. And we are in talks with a number of other countries in Asia and Latin America, for example, but also in other parts of the world. But that doesn't stop there. I think that we're seeing, for instance, new opportunities when it comes to other tools for transfers, such as what we call model clauses, which are the number one transfer tool used for exporting data from the EU. And we see systems around the world adopting similar model clauses. And that's or model clauses that are based on similar principles. And that offers, again, new opportunities to facilitate the transfers of data within those regions, but also between those regions and the rest of the world. I'm thinking, for instance, of the work on model clauses carried out by ASEAN, the Association of South Eastern Asian Nations, the work on model clauses, which is being done right now by the network of Latin American data protection authorities. Those are opportunities that didn't exist even a few years ago, and which are very promising. And then my final point, new opportunities, new solutions, also making a better use of different tools, different mechanisms we have. As the EU, of course, we don't negotiate data protection or data flow for flows of personal data as part of our trade negotiation. Those are fundamental rights. There are specific mechanisms under the GDPR, under the Law Enforcement Directive, to ensure the free and the safe flow of data. But those other mechanisms, think about trade agreements and think about investment control, foreign investment control mechanisms, can play a different and complementary role in ensuring that data can flow freely, safely, and that a number of obstacles to digital trade that have nothing to do with a genuine protection of personal data, those obstacles are addressed. So, indeed, new challenges, but also new opportunities and new solutions. That's how I see the future.
Thank you. Barbara, would you like to start with a few introductory remarks about where you are coming from?
Sure. Thank you. Thank you for having me as part of the panel. For context, from my perspective, Workday was founded in 2005 and is an enterprise provider of financial management, human resources, planning, spend management, and analytics applications in the cloud. And so from my perspective, we're looking at it as a cloud provider for global customers. At Workday, privacy protections are a fundamental component of our service. This is a very important topic to us. Privacy protections have been part of our foundation since day one, with data privacy embedded into our culture, products, and services. Workday's customers, as I said, are global customers, and so we've made great investments in privacy to be able to provide the services across jurisdictions. Workday obtained approval from the European Data Protection Supervisory Authorities for global binding corporate rules for processors. We were the first company to certify to Apex privacy rules for processors, and we're the first company to certify to the European Cloud Code of Conduct. And we invested a great amount of time in helping to form that Cloud Code of Conduct. We see great value in continuing to invest in support in practical, standardized certification schemes and codes of conduct that can help companies to build interoperability between different regulatory systems and to operate effectively across multiple jurisdictions. Similarly, we believe that the free flow of data across borders, including data transfers from Europe to the US, is critical to individual businesses in the greater economy. We remain hopeful that the Privacy Shield successor framework will continue to move forward and that we'll see similar harmonization across jurisdictions. So that's a brief context of where we are coming from today, and I'm looking forward to the conversation going forward.
Thank you very much. Thomas, you're up next.
Thank you, Stephanie. Good afternoon, everyone. It's great to be here. Great to be part of this great panel. And I'll try to be brief in my introduction, but maybe for our context, BSA, we are a global trade association that represents the enterprise software industry. So we have many distinguished members, such as Workday, who you heard from Barbara just now, companies like IBM, Oracle, Microsoft, Informatica, and many others, and all the companies are providing their services to other businesses and to the public sector, governments, international institutions, etc., to help them in their digital transformation in the way that they do their own processes, but much better, faster with digital tools and software in particular. And for that, as you service organizations all around the world, data transfers, responsible data transfers that are focused on the appropriate privacy protections, on proper cybersecurity protections, are extremely important, because it goes about building trust and confidence for all these other actors to use the tools in order to ensure that they can move on with their daily lives and daily businesses. And I'm stating the obvious here, but COVID and the situation that we've been facing for the past 2 years has shown how more and more we rely on these digital technologies, and how many aspects of our lives, both professionals and personal, are running through digital, and data flows are an integral part of that. And the landscape for international data transfers, and I think we've said it before, is going through turbulent times. It's been going on for a while, and we're seeing a lot more of calls for data localization around the world. And we see governments asking to keep the data locked up behind borders. And there's a variety of public policy motivations behind those in a variety of different countries. And not all of them are motivated by democratic values and the wish to actually properly protect fundamental rights and privacy. But central to all these discussions and these turbulent times around data transfers is not so much what companies do with the data, but it's more about the level of access that governments have to that data, in particular for legitimate purposes, be it law enforcement, be it national security, and others. But when that is the case, what are the safeguards that exist to ensure that citizens have the appropriate routes and redress mechanisms to deal with the situations when government access that data? And this is absolutely central to the recent Schrems II decision. And unfortunately, there is no silver bullet to solve this issue. There's a variety of avenues that are being considered, a variety of avenues that are being discussed today, and they all play towards the same end. How do you ensure the proper flow of data with respecting privacy? And there's two broad avenues where this plays out, and I'll go on them briefly. One of them is between and among governments, and the other one is what companies and the industry can do in that space. So among and between governments, if you take the transatlantic relationship, for instance, we're very supportive of the efforts undertaken by the European Commission, Bruno in particular, and the US government to try to find a successor to the Privacy Shield. And central to the next Privacy Shield is this issue of what kind of redress do citizens have if government access the data, and what recourses do they have in that space? But this issue is not just about the EU and the US. It concerns virtually about 160 plus countries all around the world. And so there's a lot of avenues going on in the multilateral context. Building on Japan's proposal for data free flow with trust. There's work among the G7 countries to try to find ways forward for like-minded governments to agree on what is an acceptable standard for democratic societies to access the data for legitimate purposes, but also to provide some avenues and recourses for citizens when these are abused, or even just to try to understand what's happening. Bruno mentioned it. There's tremendous work going on at OECD on trusted government access to data. We were relatively disappointed over the summer when the process seemed to have stalled, but very pleased to have seen that yesterday the discussions restarted, and there's a clear commitment to try to find some solutions, some kind of safeguard, some agreement amongst like-minded countries by the end of 2022. This is still a long way away, but the commitment and the efforts there are extremely important, and this is something that we fully support. Industry also has a major role to play in this space, and we saw it, in the context of the Schrems II decision. We saw it in the context of the new model clauses, standard control clauses that the Commission released earlier this year. There's a number of steps that companies need to take in order to ensure that they can protect the data on very specific cases, for each transfer, what kind of data are we transferring, where, what are the safeguards that we need to apply every single time. And this is something that had been going on long before Schrems II came or the new SECs came about. BSA, we released about a year ago, a little over a year ago, a document with a number of procedural, organizational, and steps that our companies were already putting in place into their own SECs to ensure that they were protecting the data in this space. We've seen recently companies, calling and making clear commitments that they will challenge requests that come from governments if they feel that they are unwarranted, and they will, try to be as transparent in this space as possible. These are extremely important and very critical to deal with. Because we need to be mindful of the implications that this has for data flows. If we restrict data flows, from an industry perspective, you can think of the compliance challenges and the impact on the companies, from that operate on different continents. But that is just scratching the surface of the problem. Today, data flow is essential to the life as we know it, and companies all around the world. BSA founded about 2 years ago an association called the Global Data Alliance that represents companies from a variety of sectors, from pharmaceutical to the financial services sector to airlines, automotive, and so on and so forth. All these businesses, all these sectors rely heavily on data transfers, responsible data transfers. And if we don't find solutions to this, every one of these sectors and us, citizens in turn, will also be impacted. And so what we need to do is to ensure that we have the appropriate governance on these matters. So I will finish in a second, but I will say just the following. We've seen a lot of global convergence toward privacy rules, as Bruno mentioned, and that is a great thing. We think that the more we converge in that space, the better we can engage. At the same time, we also need convergence of all these safeguards and mechanisms for law enforcement access to data, because if we don't solve those, they will continue to poison the well, and we won't find a solution anytime soon. And we in our companies are ready to work with governments all around the world to try to find this appropriate way forward to ensure that we create trust and confidence as we undertake this global digital transformation.
Thank you, Thomas. We'll move over to Vivian, please. Hello.
Hi there. Thank you very much for inviting me to speak today. I'm absolutely delighted to be here. I'm working for the Center for Information Policy Leadership, which is a global data strategy and privacy policy think tank. And this is actually an issue of tremendous concern to all of our members and more generally. If I could just reflect quickly actually on some of the things that have been raised already. I'm encouraged by Bruno's comments about the opportunity that we have ahead of us, which I think is so very important that we realize that opportunity in terms of finding better coherence for international transfers going forward. Barbara spoke eloquently about the efforts that her company has put in place. And the efforts, I think, there are so multiple. And perhaps that's part of what we're going to discuss today is, does it make sense for there to be so many different standards and ways and means of effectively achieving the same outcome, which is the free flow of data with trust? And then Thomas raised the challenges of this issue, both at the private sector level and then the public sector level, and then sharing information with government as well. And the multiplicity of data protection laws that are out there. The big question is it really leading to more convergence, or is it actually leading to increasing divergence, specifically in the context of international transfers? So from my perspective, we have over 190 countries in the world, and we're all at different paces of change. 2/3 of them now have privacy laws, which should be a great thing, but they do vary quite considerably. And what we are seeing is that there is an absolute shift from this fourth industrial revolution to the new information technology age in which we are going to be living and are living now. Information that previously existed only in the physical space will be digitized and converted into data, and it will be processed in cyberspace by AI and by other means day in, day out. We will live in an interconnected society. And the impact of all of this processing will actually influence and change the physical spaces that we operate in. Just like today, I'm sitting in my study in Kent in England, speaking to you in Brussels and more broadly across the world. And the pace of that change is requiring us to adapt to ensure the data transfers can occur swiftly and effectively going forward, and in a trusted way as well. What we're also seeing is the need to increase interconnectedness of systems which are being managed separately. There's a concern about centralizing data and systems, but is it about centralization, or is it about achieving increased interconnectedness? And one of the biggest trends that we're seeing at the moment, despite all of our embracing of the digital world, of living online, of being able to connect and share data in the way in which we do, is actually the phenomenon of the increase in data localization. And some of this is brought about through privacy concerns that standards elsewhere may not be sufficient to protect individuals' rights and freedoms. And so there is a desire to not share data with certain jurisdictions where it's felt that the standards there don't meet the necessary requirements to protect that data. But localization arises for a number of other reasons as well, and they can be both unintentional as well as intentional. Sometimes what the reason for data localization is a concern about security. Will information be as secure in a different environment as it is if it was physically held locally? The reality is that localization doesn't necessarily always make security better. It doesn't necessarily improve security. Yes, you've got a copy of it, but that doesn't necessarily mean that it's going to be protected anymore. Sometimes one of the drivers for localizing is a desire to promote jobs and skills within a specific jurisdiction as well, and a desire that for local infrastructure to be built. The unfortunate reality is that has a very negative impact for SMEs, who actually are the biggest creator of jobs. Over 90% of our economies in the EU, as well as in the UK, are run by SMEs, and that approach excludes them from engagement in those jurisdictions. There's a concern that regulators have that unless they can actually touch the data, unless it's held locally, that actually they don't have the ability to access it and manage it in the way in which they need. That, of course, can be resolved by putting in place regulatory controls rather than localization measures. And then there's the theme of sovereignty, which is having data locally so that there can be supposed more control or retaining sovereignty over the data. But sovereignty of data isn't about location. It's about the ultimate right to access and delete the data. And so that needs to be resolved in a different way. So if we're talking about the future of international transfers, honestly, I think that we are at an inflection point. And it's really important that we're having this discussion today, because we need to think very carefully about what direction we take. Do we continue down a bilateral or a legal approach? Do we consider standards and codes of conduct, or do we actually consider other options more broadly as well? I look forward to the discussion. Thank you.
Thank you very much, Vivian. Next up, we'll have Joe Jones, who cannot join us live, but he has sent a video, which we will watch now.
Hello, and thank you Forum Europe for the very kind invitation to join this panel. I'm very sorry that I'm unable to join you in person or actually even in real time, but all the same, thank you for permitting me a few minutes to provide some comments and reflections from the UK government perspective. So my name is Joe Jones and I'm the Deputy Director in the UK government overseeing the policy design and delivery on international data flows. I think I will start perhaps by relaying some of the doom and gloom on these policy issues before concluding with what I think and hope is well-founded optimism. There's no doubt about it, this is an extraordinarily challenging time for the free and secure flow of personal data across borders. You know, we hear time and time again from UK and international organizations how burdensome the requirements for the free flow of data have become. You know, those burdens are not just complex compliance burdens associated with Schrems II, but we're also seeing a worrying but increasing trend towards data localization. You know, that has a negative impact on both the free flow of data, fair global competition, and it can adversely favor dominant domestic markets. The global proliferation of data privacy rules, which itself is of course a good thing, is also exposing how differing and fragmented regulatory approaches can result in confusion, uncertainty, and a chilling effect on how data is used and transferred across borders. In some cases, the perceived or actual barriers to the free flow of data can be the difference between doing business in a market or not, developing a groundbreaking medicine or vaccine or not, or being employed or unemployed. That and data transfers underpin hugely exciting opportunities for innovation, trade, scientific research, financial services, and artificial intelligence. Quite simply, data flows, data transfers have revolutionized our way of life and our economies. So the stakes could not be higher. But to compound the need for action is the fact that there are genuine and credible opportunities out there all over the world. I mentioned the proliferation of data standards. Some estimates put it at over 140 countries now with data privacy legislation. That's an astronomical increase from just a few years ago. We can be at an inflection point here if we invest appropriately in the right opportunities. This is one of the greatest opportunities of our time. The better use of data enabled by cross-border data flows has the potential to transform almost every part of our society and economy. I won't go into detail into everything the UK government has done or seeks to do, but there are three specific targeted things that we're working on that are worth mentioning. The first is, of course, how in June this year, the UK secured data adequacy from the EU. That followed more than a year of talks. It was and it remains incredibly important in order to provide that continuity and stability to UK and EU organisations. We enjoy a very positive and strong relationship with the European Commission, and I very much hope that as joint partners we can work together to promote responsible, trusted and free flow of data across borders. My second point is looking ahead and looking further afield. You know, there are hugely exciting opportunities with partners around the world, from Kenya to Colombia, from Dubai to Australia. In August, the UK government published our most near-term and our longer-term priorities for data adequacy partnerships. We're in talks with countries in every continent of the globe, and there are many more countries that we're engaging with beyond those we announced in August. How we deliver this work is so important. You know, we will remain steadfast in our commitment to high data protection standards, but we also recognize and understand the cultural context of privacy, the global variety, and how exactly countries regulate privacy. No two countries will have the same data protection framework or laws, nor should we require that. A more open and more creative approach will unlock the ability to respond and to act more scalably and increase the number of data adequate countries. Thirdly, and finally, these are noble pursuits, but the UK cannot do it alone. Indeed, nor can the EU. I don't think we actually want a future where we have 150 countries with 150 different lists of adequacy destinations, 150 different sets of contractual clauses. There is a great opportunity to come together to exploit a more flexible approach, create a more globally interoperable model for data flows that works in harmony with other systems. The UK is using its international influence now, investing in multilateral fora like the G7 and the G20, want to drive forward global solutions to the challenges and the barriers that exist and that are impeding cross-border data flows. We used our G7 presidency to achieve consensus on a roadmap on the data free flow of trust. We're working very hard with our partners at the OECD to agree principles on what good trusted government access to data could look like. That's a set of issues that is vexing many following the Court of Justice ruling in Schrems II. Global challenges and global opportunities on international data flows require global solutions. You have a superb panel to discuss these issues, and I shall very much miss the conversation and the insights. Thank you and enjoy the conference.
So that's our panel. I am at the EU courts today here in Luxembourg, and so it might be quite a natural start to go into a question about a key decision that the European Court of Justice took last year in a case often dubbed the Schrems II decision. The EU court last year annulled the EU-US Privacy Shield, the EU's second transatlantic data transfer tool adopted after the EU's top court already in 2015 struck down its earlier mechanism that was called the Safe Harbor. These agreements formed the basis for thousands of companies to freely let data flow across the Atlantic. But the European Court of Justice rulings created a legal vacuum, which the Commission is now working hard to fill. The key question now, and I suppose Bruno would like to go first, is how can we, what's happening, what's the latest, and how can we avoid a Schrems III?
Well, I don't know what you mean by avoiding a Schrems III. The fact that there is litigation and that the court, that individuals or organizations bring cases to court is good and healthy. The question is, how should we avoid losing in court, and how should we avoid that the court quashes once again a data flows arrangement with the US? There, the answer is very simple, and I think it was reminded by Vice President Jourova at this event a few hours ago, meeting the court's requirements. And the court's requirements, as you know, are essentially about two aspects: limitations, conditions, safeguards around access to data by US authorities, in particular US intelligence authorities on the one hand, and then access of individuals, Europeans whose data is transferred to the US, access of Europeans to a court, to a judicial redress remedy. Things that are quite basic, but that are very important. And where we are on this, so indeed, we have negotiations ongoing with the US, with our US counterparts on this. The negotiations are intense. We are no longer at the sort of exploratory phases. We are now into the substance of what needs to be negotiated on these two aspects that I've briefly recalled. We have made a lot of progress, and we have made good progress, but we are not yet there. I guess the next question, or the question of the audience, is when do you think you will be there? That's not the good question. The question is really should not be the when, but it should rather be the what. The when could be tonight, if we could find a solution that is in line with the Schrems II requirement. But as I said, we are not yet there. And we should not certainly sacrifice quality over time. Because as you said, and we believe for very good reasons, this arrangement, this issue of data flow is subject to a lot of scrutiny, political, legal scrutiny. If we want to ensure the protections and the legal certainty stakeholders, business, citizens deserve and expect, we will do this only by delivering and concluding an arrangement that is fully compliant with the Schrems II requirement. So that's where we are, depending on the days, we are more or less optimistic, sometimes more optimistic than on other days. But believe me, on both sides of the Atlantic, there is a lot of work going on, a lot of work put in those negotiations, and a willingness to succeed. But to succeed, certain key conditions have to be met, and we're not yet there.
I have so many questions I would like to ask you, Bruno, as a follow-up, but we have a big panel, and I know that Thomas is probably very eager to chime in now. Thomas, please.
Yeah, no, thank you, Stephanie. And just quick caveat before I start. BSA, we were an amicus curiae in the Schrems II case, not because we represent Facebook, but because the issue at stake, which was not the privacy shield, was extremely important for our companies and all companies around the world that operate in Europe, but have, customers, business partners, supply chain outside of Europe. And it was the standard control clause. That was what at stake really in the Schrems II case. And that thankfully the court upheld. The court upheld it and recognized that no two transfers are alike. And that while using the SCCs, companies need to assess, on a case-by-case basis, the type of data that is transferred, the destination, what are the potential pitfalls there, and what safeguards can and should be applied in this regard. And the court has recognized that it needs to be assessed on a case-by-case basis. On that basis, the Commission came out earlier this year, actually, with new SCCs that recognize that. That is extremely important and very important, because this is and Bruno said it, I think, in his introductory remark, this is the single most important data transfer mechanisms that exists. And that is upheld, strengthened, is important. Now, it raises a lot of other questions, because now companies need to do an assessment of 160 plus countries around the world, depending on where they want to send their data. They need to assess not just the laws, but also the practices, which, frankly, sometimes it can be challenging. And on that basis, add additional safeguards to ensure that, this can actually continue to happen. Now, for large multinationals, for companies with resources, this is something that can happen. Now, to Vivian's point earlier, how do we deal with the SMEs that also want to do that and have that responsibility that falls upon them? That is the big question. I think having and I think, Bruno, you mentioned that a couple of weeks ago at a conference, that the Commission is supposed to release some FAQs on the SCCs, on how companies can, have additional guidance that is helpful, that is needed, that is something that we would like to see, because that would be helpful in this very volatile environment. And I close on saying that, yes, I mean, the privacy shield, is an extremely important transatlantic tool, and Bruno knows that, the US government knows that. We, our members, are very supportive of their efforts. Anything that we can do to help, to facilitate, we are there, we're ready. It goes about, all our companies, all the customers that they serve, that all looking for one thing, which is legal certainty for responsible and protective data transfers.
Anyone else who would like to have a go at this rather tricky questions? We are, what happens after Schrems II, and where are we at, and what kind of issues has it created for industry? I mean, you all come from different points of views. Oh, Bruno, would you like to respond to Thomas?
No, indeed. I can only say that we perfectly understand that model, meaning the needs of small and medium companies, and that's why after Schrems II we decided to prioritize the work on model clauses, because model clauses, although we also understand that their use might not always be easy in the post-Schrems II environment, model clauses are the most helpful, not only the most frequently used, but the most helpful transfer tool, because they have this sort of, if you want, off-the-shelf effect, that those are, they are ready to be used. Of course, they have to be adapted to your own processing operation. And that's very useful for companies that may not have all the resources to deal with complex compliance operation. To further facilitate that, we have collected a lot of feedback on the use of these model clauses, because they are now being contracts. Model contracts are being negotiated, and so we receive a lot of feedback from the ground on questions, difficulties, complexities. We are now collecting those feedback and preparing, we believe, very user-friendly Q&As that will be online, on which stakeholders will be able to react, that will be updated frequently. I still think model clauses have a very big role to play. Certainly for SMEs, they are much more interesting than much more expensive tools we have seen. Other tools we've seen, I'm thinking, for instance, what exists in APEC, etc. So for us, it remains a priority. We will even enrich the model clauses we have adopted with a new sort of model. What is a model? It's a transfer scenario that we haven't covered in June. So that remains really at the core of our work. And as I said, also, that will be my last point. There is a very novel situation now where other jurisdictions in the world, other systems, other regional organizations develop their own model clauses. We believe very often on the basis of similar principles and safeguards than ours. So this possibility of bridging model clauses, the European one and the one of other regions in the world, will also, I think, significantly help stakeholders present in both jurisdictions. So that's a work stream we very much believe in.
Thank you. Vivian, I think you wanted to have a...
Thank you. Yes, I think the focus on SMEs is really important. As I mentioned, most businesses are SMEs. And if you consider the amount of time, effort, budget, resource, and legal advice that's going into the massive repapering exercise being undertaken in order to comply with Schrems II, and even then the question is it possible to fully comply, particularly when you're having to assess the suitability of third country jurisdictions? You know, no two law firms are going to agree on the suitability. So much of it depends on the context and on the data and the type of transfer and so on and so forth. And it really is quite hectic. I'm absolutely delighted to hear that the Commission is looking to take on board some of the feedback around what is frankly turning into a frenzy of contracts out there, and to consider how to make that more user-friendly. So certainly from a UK perspective, one of the initiatives that's been proposed is that that there would be an add-on, effectively, a short addendum, which companies who've embraced the EU model clauses can just add on this page, and then it's going to work for the UK as well. And that modular interoperability, mutual recognition type of approach just seems to make an awful lot of sense. It shouldn't be for companies to have to engage their lawyers to try and work out the complexities and interaction between all of these different requirements in order to figure out which clause goes where, etc. That modular interoperability seems to make an awful lot of sense. But I suppose my bigger question is are we doing the right thing by going down a contractual approach? So when you set up, this is me being back as a lawyer, a commercial lawyer, a technology lawyer, you don't start with the lawyers, you don't start with the contract. You start with the parties and a vision or a mutual benefit between the two. That's what brings you together. The contract is there to set out the parameters and some of the commercial terms to set them out so that they are clear. And you hope you never go back to the contract again. You hope that the relationship is going to work just perfectly. And in fact, you never have to resort to the contract. And I think perhaps one of the challenges we have now with international transfers is that we're thinking too much about the contract, not about what we're trying to achieve and what we need to achieve. and why SMEs need to transfer data, why all organizations need to transfer data. And perhaps we should be thinking that the contractual approach should not be king. And perhaps we should be thinking, particularly for SMEs, should they be entering into multiple contracts, however potentially user-friendly they should be, or should they be able to adhere to sectoral or regional codes of conduct that will enable them to then participate? And where I'm going on this really is should we be thinking more carefully about an accountability model and mutual recognition rather than a legalistic approach in order to really crack the nut on this? Because I'm not sure that continuing to perpetuate more and more contracts is going to help, because they don't line up side by side. There are ways which you can try and paper over the gaps, but maybe we should just take a step back and think, as we are asking the future question here, is that the right approach at all?
Thank you. Bruno, I'm sure you want to respond to that.
Don't want to monopolize the thing, but first let me say that what Vivian just recalled, that was one of the possibilities, one of the options that is considered in the UK, indeed, to have a interoperable set of SCCs. That's, by the way, also what Switzerland has already done. That's, of course, something which is very welcome, and that shows that these SCCs are actually very useful. Otherwise, we would not see those kind of proposals. Never said that contract is the only, first, never said that there is a one-size-fits-all solution for data flows. On the contrary, that's not what the GDPR says. The GDPR has adequacy, has contracts, but also has codes of conduct, has another system of certification, which are for the moment underdeveloped. And that's another of our priorities, to work with the EDPB, the European Data Protection Board, body that brings together the enforcement in Europe, because this is something where we have a co-responsibility to develop those tools. But we need to be very clear. Accountability, interoperability, all these are words that have been used for a long time. But what companies need, and we're all working in making different systems speaking, but what companies need is, first of all, legal certainty. And legal certainty in an issue that concerns fundamental rights. And Stephanie, you're speaking from the European Court of Justice, and they know that better than anybody else. Needs binding rules, invocable rules, and needs enforcement and oversight. And for that, you need hard law and hard commitments. I totally agree that those hard law and hard commitments can be provided through different mechanisms, and contracts are only one of them. And we have tried to simplify and avoid this sort of multiplication of contracts by allowing several companies to join one contract with the STCs. We are, as I said, working with other organizations such as ASEAN, so that we have tools that will work that not only with one country but with a group of countries. There you have a critical mass, and we're going beyond the bilateral dimension. But at the end, and that's why I very much believe on convergence of legislation, because that is what we need for having solid, durable, and reliable solution. You need hard law, you need courts, you need oversight. I mean, this is a matter of fundamental rights, and it's not only a slogan, because as the place where you're sitting, Stephanie, as that place knows very well and teaches very well, we're not talking here about normal tariffs or custom barriers. We're talking about fundamental rights, and that needs certain mechanism, and that have to be sufficiently credible, robust, and also supported and backed by real enforcement.
Thank you. As I said, I think we could dive into these issues for many more minutes and probably hours, but it would be good to address a few other topics and potential challenges when it comes to data transfers and international data transfers. Surely when it comes to data flows, Brexit and the EU-UK data adequacy decision that has now been adopted. But they have triggered some kinds of concerns, especially about fears or concerns that the UK might be moving away from the EU's strict GDPR rules. Joe, in his video message, spoke about how the UK is looking at the cultural context in different countries when dealing with data, and that the UK encourages a more open and more creative approach on data adequacy. He also says neither the UK nor the EU can do data adequacy alone. Who would like to go first in responding to these arguments and on this topic? I know, Bruno, you're very afraid to monopolize, but we're very keen to hear from you.
I'm not afraid by the question, but Vivian, please go first.
No, thank you. I was going to say, well, shall I go first, seeing as I'm actually sitting in the UK?
Absolutely, please do. And also, you and Joe both spoke about that we are at an inflection point. So I think when it comes to the UK situation, that's probably quite topical as well. Please go ahead.
Yes, absolutely. So I think, the UK has a stated ambition to move forward in terms of data protection. And Joe expressed it very articulately. I don't think I can quite match his words. But I think one of the things that is top of mind for many people is the recent consultation that the UK had published on UK data reform. And it's actually, it was a long document, and it, through CIPL and others, we've put our responses together across our members. And that reform consultation was, it was incredibly ambitious and incredibly broad in what it sought to cover. I suspect that perhaps some organizations felt a bit disconcerted by the questions that were being asked. But actually, the reform consultation was based on an enormous amount of feedback that the UK had been taking for quite some time, particularly in relation to the UK National Data Strategy consultation the year before. And so, they've literally asked questions like, do you need to mandate a data protection officer? Do you need to make certain, do you need to mandate certain measures of how you comply? Or is it okay? Well, sorry, so what do you need to do to comply versus how you need to comply? Do we need to be so specific? Can we leverage the accountability framework and approach in order to build better data protection compliance within firms? How do we encourage firms and organizations to have and to implement privacy management programs that are global, that achieve consistency and actually lead to real outcomes, not policies that are published on a website, but practices that can be measured, that can be reported on, that can be addressed where things don't go according to plan and so on. So it was very ambitious, and the feedback, I suspect they're going to get a very broad range of feedback as well. There were also questions about, how should the UK ICO be structured going forward? And there was a lot of feedback in relation to that, because I think we're very proud of the UK ICO. It's an incredibly well-resourced and well-respected regulator globally, and has taken a considerable amount of not just enforcement action, but thought leadership as well in terms of tackling some really difficult issues, leading the way. Maybe we don't always get it right, but at least we're willing to have a go and see if we can make some headway on some of these really difficult issues. So I think there's a few things, the approach certainly to adequacy measures elsewhere. I know, Bruno, you talked about convergence of legislation. I think the challenge we have is that every country does things differently, whether it's common law or civil law, whether there's a cultural context, a political angle, a predominance of certain business areas, and so on and so forth. So I don't know that I would necessarily express it in that way. But what I think we do need is a convergence of views in terms of what are the outcomes that we're looking to achieve, particularly around the protection of individuals' rights, about redress and such like. Is it about lining up the laws next to each other, or is it actually looking at, what is the impact, what is the effect? Because I'm not sure that we're going to get convergence of laws when every country is its own sovereign nation. and will do its own thing. And I think it's actually really interesting part of the UK to be looking at other jurisdictions. And yes, the law is different, and yes, the approach is different, and their legislation is different. But are we seeking the same thing? Are we actually looking to build trust in relation to data, the same positive outcomes, so that actually we can allow the free flow of data in a way that individuals' data is not going to be put at risk?
Happy to react to that if you want. It's music to my ear because that's what we have said and that's what the Court of Justice says. Meaning, if anybody thinks that this is new, he or she is wrong. Of course, adequacy, for instance, is not about identity. The Court of Justice in the Schrems 1 judgment said it itself, black and white. And of course, we don't look, meaning legislation, and important legislation, such as data protection legislation, is influenced by legal cultures, by societal choices. We would not have found as adequate countries as different as Japan, Korea, and others if we were applying a mechanic point-to-point test. We are always assessing a system in its globality and seeing whether that system, taken in its totality, delivers a certain level of protection. That said, I don't think that there are many ways, different ways to ensure basic things as an independent supervisory authority or access to court. Procedures might be different, but at the end, you have to end to a court. So I'm not sure, you know, there are different ways, but we should also be careful in not taking on a human right a too relativist approach. There are fundamental rights that have to be ensured in different ways, but that have to be ensured in any system. So on that, I think nobody will disagree. And that's the challenge and the beauty of our international work is to try to find commonalities between different systems. And I think we are very encouraged by what we are seeing around the world. On the UK consultation paper, it's a very interesting paper. It's actually a very mixed and diversified bag. There are proposals that are probably aimed at providing additional clarity. There are proposals that if they would be endorsed, because this is still an ongoing process, there's no formal proposal by the UK government. If they would be endorsed, if they were to be endorsed, would lead to legislative changes. Other options would lead to probably guidance by the ICO. So it's very diversified in terms of contents, in terms of possible outcomes. It is clear that we are looking at this very closely and with a lot of interest. We have found the UK system adequate a few months ago. If the UK system would significantly change, it would be a different system. And it would no longer be the system we have found adequate. That's why we are looking at this very closely. And that's also why we have been in close contact with Joe and many of his colleagues to first understand better where they're coming from on some of these proposals and what are the next steps and what is the process. I must say, and as Vivian has recorded, this is a consultation. There have been a lot of feedback. I think more than 1,000 feedback, extremely good and not surprising. The UK has always been a very active actor. Its civil society, its courts, its data protection authority have always been very active in the data protection debate as part of the EU family first and now as part of the European family. And we had this, we are therefore, as I said, looking at this with a lot of interest. As I said, there are many aspects that are more of a clarification, but there are a few aspects that clearly raise questions on our side. And we need to work so that those questions don't become issues and then problems. I'm thinking, for instance, about some of the proposals made around the ICO, the UK Data Protection Authority. Some of these proposals could suggest that the independence of the ICO would be weakened. Actually, the ICO itself said it in its submission to the consultation. So that's something we certainly have raised and have stressed as an important point in our overall assessment. Another example are some changes that are proposed around some legal grounds for processing. What's that? Meaning it's the legal basis on which you have to base yourself to collect and process data. That's a structural element of any data protection system. If there would be significant changes there, and if those changes would lower the level of protection, that would be an issue for us. So it's important to say those things sufficiently in advance, and so that meaning they are well understood on both sides. There has been as I said, a rich consultation. There will be now, I guess, a lot of work for Joe and his colleagues in digesting the consultation and deciding what should be done next and which option should be brought forward. Finally, let me also maybe stress another point, and the final point. Everybody is, I understand, very focused on the adequacy aspect. What it would mean for adequacy. I'm certainly not here to say that this is not relevant. But, this is first of all a reform by the UK for the UK. And the UK, actually, and UK businesses and UK stakeholders have implemented the GDPR. The UK was actually a very active actor in the development of the GDPR. Today, the GDPR is applied in the UK. A lot of UK businesses will continue to offer goods and services in the EU or to receive data from the EU. Our economies will continue to be interconnected and closely integrated. Therefore, I think there is, but that's a question. It's a question for the UK public, and I think it's a question that has been indeed raised in the consultation. To what extent is it worth having now a different set of standards, which will lead to actually compliant cost and red tape for companies that, on the one hand, will, when trading with the EU, will have to apply a certain type of standards, and in a purely domestic setting, will have to apply another set of standards, when we are talking about companies that already apply fully the GDPR. So I guess that's also an important question, and a question that goes well beyond the adequacy dimension.
Thank you. I'm just wondering, how concerned are you all about a possible court challenge over the UK's plans? And maybe it would be good to also hear from Barbara to see what kind of challenges this brings for organizations that operate across the channel.
Sure. Hopefully I'll stay here. Apologies, I've been having some connectivity issues. But I mean, right now, I think this was a proposal, as Vivian said. There's been no indication that the UK government is about to implement any of these. It really is a proposal. And so, Workday submitted comments on the consultation, and, we really believe that the regime should remain interoperable with others, that it must maintain high data protection standards. It has to remain interoperable, particularly with the GDPR. As we were just talking about SMEs, having that adequacy decision makes transfers so much easier for SMEs in order to comply versus trying to come up with different mechanisms for transfer, different standards. But we do think there's helpful ideas in the consultation, and I think these have already been referred to by my prior panelists here. The international data transfer agreements, having the UK adaptive addendum alongside the SCCs, all of those are very positive and will be helpful for the data transfers, especially coming at it from a US perspective. We also, as a company, really welcome the government's proposal to modify the framework for certification schemes and to look at a more globally interoperable market-driven scheme. But that being said, we think it's incredibly important for it to remain interoperable with the GDPR and for that adequacy decision to remain intact.
Thank you.
And maybe if I just let me add that, of course, we had, to a certain extent, anticipate that, because, of course, our adequacy decision gives us the possibility to react to changes that would be problematic and that would significantly change the system we have assessed as adequate. We have a stronger suspension and termination clauses. We have a sunset clauses. We have seen during the decision-making process on the two adequacy decisions for the UK, one on the GDPR and one of the law enforcement directive, that we had, for instance, to exclude an area, which is not so relevant for today's discussion, but transfers for immigration purposes, because there we had a doubt actually created by resulting from a judgment of the Court of Appeal of England and Wales. So this is what I'm saying is not only theoretical, we would be ready to use those tools, and those tools are there to be used if there would be a problematic divergence. As I said, we are, and as everybody has stressed here, we are at the level of a consultation process. No formal proposal has been made, and we are keeping a very open and frank dialogue with our UK counterpart on all of this.
Okay, thank you. Thomas, before we move away from the UK to China, please.
I wanted to just add one more thing, I think, on the UK. And I think one of the things, I mean, I agree with everything that's been said. I think maintaining the adequacy is important, ensuring that it continues is very important. One of the things that I would like to stress, which we think that the ICO did well, is in their new SCCs, or the proposal for the UK SCCs, and Vivian talked about, this addendum that could actually ensure the interoperability with the EU, which is a great thing, which we hope that other regulators around the world or other countries that decide to look at their own SCCs can also take on board, because having this these addendums make a lot of sense. But the ICO went one step further, and we think is very interesting, is that because the UK SCCs very much track the EU SCCs, and part of the job that needs to be done is assessing third countries' laws and practices of law enforcement and or government access to data. And what the ICO did is that in their draft, they proposed actually a checklist of what actually would be relevant for companies to do, which is extremely important and really helpful, because the Court of Justice in France too said, well, you need to look at third countries' law and regulations, but without giving much more details. And having that level of details, which can be always expanded on or changed, or actually gives an indication on how companies can actually look at other companies that really want to do this, have clear roadmap to do that. And that is an important element that we think is good, and that can actually be emulated, and then hopefully some of the other European DPAs could also think about what exactly they think would be relevant, and that give more clarity and more guidance for companies willing to be using these mechanisms.
Thank you all. As I said, we're going to move from the UK over to China, and where since November the 1st, there's a new personal information protection law in effect. So this new rules, they include cross-border transfers and can lead to quite hefty fines for violations. So just wondering from the panelists what some of the challenges are that this is creating for companies. And also another question is whether this could become the new international standard above GDPR. Who wants to go first?
I'm happy to go first, sure. So actually, I think everyone's been watching this with tremendous interest, because it isn't just the privacy law that's come into effect. There's been a whole suite of legislation, particularly the cybersecurity law and the data security law as well. So I don't think you can sort of view it as one piece of legislation. There's a huge suite of things that are taking place. And actually, it's interesting because I think it's one where certainly we're seeing it on the EU side and on the UK side and in a couple of other jurisdictions as well, this awareness of the intersectionality of privacy with other areas that also process data, and thinking more holistically about, like an EU data strategy or a UK national data strategy, or what is clearly here is a China national data strategy that goes beyond just privacy, but also talks about telecoms and security and regulated entities and so on and so forth. I mean, what we've seen certainly with regard to the China legislation is it's come in very quickly. that's very far-reaching. There's still some areas that need to be clarified. There's a tremendous focus on localization. And I think for many international companies, it's going to be incredibly difficult to actually comply because a lot of BAU processes that happen today technically probably can't happen under the new legislation. So, it's normal data practices like daily, HR management or due diligence that you need to do on clients and so on and so forth are subject to real challenges. Processing of sensitive personal data as well, a real challenge. And there's a very, very strong push to a localization approach there, which I referred to a little bit earlier in my opening remarks. So, I think China's taken a very specific view. There's a strong national interest theme that runs through the suite of legislation. The penalties, as you mentioned, are incredibly high. So I think this is an example of a very significant jurisdiction taking a holistic approach to personal data as well as other data and imposing a very sort of data sovereignty, localization approach toward information that is going to be very challenging for companies to comply with, and I think is ultimately going to lead to a significant amount of localization as a result. But yes, it's very complex, and the thing is, it's still evolving, so only time will tell.
Thank you. Any thoughts, Bruno, about whether this could become a new international standard and not GDPR?
Well, I think it tells us three things, and some will echo some of our previous discussions today. First, it says, well, a clear recognition. It's important because a clear recognition by China of, indeed, totally agree with Vivian. This is not only about data protection, that there's need for some rules or for some rules of the game in the digital sphere. Whether we like them or not, that's another question. Probably it is also linked by the fact that we see increasingly Chinese tech companies, Chinese social networks active and present in foreign markets. Big difference compared to even a few years ago, and when you are present on certain markets, etc., that needs to also to go with a certain, trust, if I may say, and therefore I think that's an indication. It is for us a confirmation, and we had this discussion a few minutes ago on data flow, that data protection is not only about technical standards. If data protection would be about technical standards, you just define purpose limitation in a certain way, you put certain grounds of processing, and here you have the same law or compatible law. Data protection is part of a broader human rights, fundamental rights ecosystem and legal environment. For having genuine data protection, you need to have independent oversight, including over the public sector. You need to have access to court and effective judicial redress. That matters when you're talking about rights, individual rights, human rights. And once again, Stephanie, you are sitting in probably the most relevant or appropriate place in that respect. And probably it's a wake-up call to like-minded countries, us, others, the US. The US hasn't yet a privacy legislation, while China has one. That's also something that probably, if you look at this in the broader context, is a signal. And it's probably a wake-up call for us and for like-minded countries to work together to develop standards, because there is an increasing demand for international standards on privacy. And I believe that it's better that we shape those standards with partners, with like-minded partners that share common values, common principles, rather than have those standards developed by others. And this brings us to the need to solve the privacy shield issue. and to solve it in a durable way, because once again, if the EU and the US cannot solve this and cannot agree on such fundamental principles, who can and who should? And it also brings me to the important role and the important work in the OECD, which is based precisely on that idea. Let's meet and let's work between like-minded countries to develop some basic principles on governance access. So I guess in terms of many important and main messages, those are the one I see. And then of course we can dwell and go into the details of the legislation. I'm sure we will come back on data localization later in this discussion.
Thank you. Who else wants to talk about the China new rules, which obviously are not as limited as I indicated initially? And also to Bruno's comments, he constantly says, I'm in the EU court. I need to add a disclaimer. I don't work for the EU court. I just am a journalist sitting in the press room of the EU court here in Luxembourg, just to make that clear.
You are just the most famous journalist covering the EU courts of basis.
Well, one of a few, but I'm the only one actually based in Luxembourg. That's true. But going back to the panelists, it's not me who is the star today, it's the panelists. I mean,
Stephanie, I can do a few words on this. I think, yesterday, VSL alongside another 26 organizations sent draft comments to the Chinese government on their, draft data transfers assessment measures. And I think there's a number of things that we find, we and other groups find relatively concerning, because some of these rules seem to impose greater restriction on data transfers than are actually really necessary, and that we'd like to see some clarification being given to that. There seems to be some kind of unequal treatment according that you are a domestic or foreign player enacting there, and that creates some concerns. And also, want to be sure that that's whatever happens there, it's administered in a uniform, impartial, and reasonable manner. That does not lead to discrimination, of approvals, for the data transfer. So there's a number of things that we've raised there. We'll see whether that's taken into consideration or not. But these are some of the concerns that some global industries have shared with the Chinese leadership on. And again, it's on the criminal. Cyberspace Administration of China's data transfer templates that was published recently. But I would like to go back to Bruno's point, because I think one of the things that he mentioned is what actually I said in my opening remarks, focusing on how like-minded governments can work together to create not only, the convergence of rules and the way to look at privacy, I think is not very different amongst these like-minded countries, but what we need to solve is law enforcement access. What are the safeguards? What is acceptable in our democratic societies? And the faster we can move on this, the better we all be. And we can actually set probably a global standard in that regard. And that's why I was commiserating. I was expressing some disappointment that the OECD process had stalled, last summer, where, but we're really, really pleased about yesterday's meeting and the level of ambition that's there. So, again, I think, we, a number of other groups, the OECD members, want to achieve something, because that's the only way that we can actually bring a little more clarity, bring a little more, ambition, and not necessarily solve the data flow issue once and for all, but at least go all together and speak with one voice and go in the same direction. And that's extremely important, something that we need to be really focused on and support wholeheartedly.
Thomas, you brought up the issue of law enforcement, and maybe that's if that's something one of the other panelists or you want to say a few more words about. The question here is also how to resolve this challenge of finding the right balance between privacy protections and cross-border law enforcement more generally, not just moving away, but more globally from the China topic that we were just talking about. I know it's not an easy topic, how to resolve this, the potential challenges on this, but
it's not an easy topic, but one on which we see first that there is recognition at international level that this, to avoid conflict of law and to avoid that it's at the end stakeholders and businesses that have to reconcile or not different requirements. So there is a recognition that for the need of international solutions on that. We see that in the OECD, but we see it very recently with the conclusion of the so-called additional protocol, the conclusion of the negotiation of the so-called additional protocol on the Budapest Convention. So it looks like another Brussels or not Brussels technical lingo thing, but it's actually a very important convention on cybercrime, which has been created by the Council of Europe, but has members from all over the world, more than 50 members from the US to Australia, New Zealand, some countries in Africa, in Latin America, etc. And an additional protocol to that convention was the negotiation of such additional protocol were recently concluded, and they provide for international rules on things like indeed access and direct access of law enforcement authorities to data. So all of this shows that there are ways to indeed do that balancing act at international level with binding rules, therefore, which are agreed by government and therefore which provides and deliver legal certainty. It is a balancing act, of course. It is, and this is always complex. It's complex in the context of Budapest. It's complex in the context of Privacy Shield. It is complex for the EU as it is complex for the US. But I mean, we should be encouraged by those and other examples. And as you know, the EU has, for instance, also a mandate to negotiate an agreement with the US on so-called e-evidence and access to such e-evidence. So you will see more and more of that work in the coming years, because I think, and once again, we should be encouraged by that more and more partners, countries around the world realize that this cannot be dealt only at a domestic level and cannot be left to traditional conflict of law solution.
Stephanie, I would like to just, totally agree with Bruno. I think, these issues are for governments to actually solve, because, as industry, we're faced with applying laws and regulations the way they happen, and trying to sometimes, conflicting ones is tricky, and it's a balancing act. So, again, fully supportive, and Bruno rightly mentioned, the work on e-evidence. I think there's a lot of, we're seeing today in Europe, in other parts of the world, a lot of concern about what's called the US Cloud Act agreement, or the US Cloud Act. And so I'd like to touch 2 minutes on this, because this is too important to be left alone. First of all, I think when we're talking about legislation in third countries about law enforcement access to data, we also need to be clear about what these laws and regulations do and what they don't do. And I think knowing about the scope and what kind of data can be requested to whom, to which type of companies is important, because that doesn't mean that, there's unfettered access or unfettered requests that happen. Also, some of the requests don't concern Europe. So there's a thing that we need to clarify and be sure of what we're talking about. At the same time, we're seeing, within the EU member states, the e-evidence negotiations have been stalled for, I don't know, a year and a half now. So there's a clear need for our 27 member states to agree on the rules just for Europe, and then we can start talking with our American partners about how do we create this framework where companies, citizens feel comfortable that, okay, well, their governments have a legitimate purpose, for law enforcement purposes. Yeah, that's what their role. There's also safeguards, there's also remedies, there's also redress that need to exist for citizens, and making sure that we get them is important. But again, it's governments have the final say in this, and that's why we as industry, we can only support all these efforts that seek towards this convergence and working together to get the situation a lot calmer than it is today.
Thank you. Barbara, I'm sure you wanted to say something as well.
Yeah, again, I'm echoing what my fellow panelists have said here. But we absolutely think that cross-border law enforcement access issues have to get resolved. And the only way they can is by liberal democracies, across the world who are facing these same challenges, coming together, ensuring that strong privacy, fundamental rights, safeguards are in place, as well as enabling effective law enforcement capabilities. So we strongly support the effort underway in the OECD to find this common ground among like-minded countries and, trusted government access to data. And we're hopeful that this process will lead to a broad multilateral consensus about the principles that should underpin rights respecting government access laws and practices. At the same time, I think we have to also be looking at other tools that are coming out, other processes that might be coming out. So keeping a close eye on what's happening with the EU-US Trade and Technology Council, the developments that they're putting in place. I know it's new. There's only been one meeting so far. It just launched back in June. There's been one meeting in September. But we see that as a positive in terms of, resetting EU-US bilateral relations, looking at a way in this increasingly connected global economy that these like-minded democracies can come together to work on a shared vision for the future of technology. So hopeful that we continue to see more tools like this, what's coming out of the OECD, what's coming out of the Council, as a path forward.
Thank you. I'm going to change topics completely because I wanted to ask your views about this brand new diplomatic initiative that we now have, the EU-US Trade and Technology Council, which met for the first time in September. And their goal is really to work together to shape the rules and standards around crucial technologies and coordinate approaches to key trade issues. What role do you think could this council play in shaping the future of data flows?
I can jump back in on that one since I touched on that one. I think it's still new. I think there's still some time to see what comes out of it, but it's incredibly positive that working together and to go to the prior comments and even looking at where these data protection issues are going around the globe, not only to focus on what can come out of the council in terms of work on data transfers, but also looking at other pressing tech issues such as AI regulations, cybersecurity, and more. It's a meaningful touch point to ensure that these issues don't become insurmountable hurdles between the EU and the US. I think it's still yet to be seen in the long term in terms of how the work comes out in terms of the data transfers. But it's positive that these meetings are happening, that these discussions are happening, and that there's a forum to address these larger big tech issues as well.
I'd just like to add that I think it's an incredibly positive initiative. And the thing that I like about it, it's great that the EU and the US are coming together. But what's more important is that it's an example of a proactive approach. Rather than waiting for an issue to arise, there's actually a positive engagement to explore how we can navigate the increasingly digital environment in which we live, the innovation that we are all looking to embrace, and find a way forward where we can have some mutual understandings and agreements on how it should be addressed and how we address some of the potential risks that may arise, but also how we can leverage some of the tremendous opportunities. So rather than waiting for an issue to arise, I'm very encouraged by the fact that this collaboration is proactive and positive in its intent, and hopefully it'll actually lead to greater collaboration going forward. Thank you.
We have just a few minutes. Bruno, please.
So I will be very short. I agree with everybody, with what everybody has said. Very important, very ambitious and important agenda, touching upon all sorts of tech-related issues, but not data flows. There is already a format for the EU and the US to negotiate on data flows, and those are the privacy shield negotiations. It's a very different exercise. This is not about comparing notes, developing a common agenda. This is about agreeing and negotiating a binding arrangement, and for that, the format of the negotiation format is the most appropriate. We're talking about exercise of a very different nature. And we've seen so that this format is the appropriate one. As I said, we have made progress. So, the TTC has an incredibly important role to play on a very wide range of issues, some from the most technical to the most fundamental. But don't expect the TTC on data flow. That's not the place and the right forum. Sorry.
Yeah, just to comment, again, agree. I think the TTC is tremendous because there's a clear platform for the EU and the US to talk and discuss on a variety of very important issues on trade and technology, on how we see the future. And basically, it's about the digital transformation that I was mentioning earlier and how we deal with that in that space. And and Bruno is right, there won't be specific data flows provision there. I mean, DG Justice, unfortunately, is not part of the TTC.
We are, but on other issues.
Okay. Anyways, but it's the issues of data governance, and Barbara mentioned it. As there's development of rules in the EU on artificial intelligence. The US is thinking about the same, working together to try to come up with not necessarily the exact similar approaches, but converging approaches on how do we deal with, high risk in AI, how you deal with bias, how do you deal with all these things. The data itself, the governance is important because all of this creates a common understanding and a similar way to look at things that will help ultimately in pursuing other arrangements for transfers and for the data to be used and for the benefit of first of all the EU and US, but then broader thinking of like-minded partners who can also be emulated in that, who will be emulated from that exercise. So it's a great tool. And again, it's very supportive, and looking forward to these to be continued and strengthened. So yeah.
Thank you. Given I am at the EU Court, a journalist at the EU Court, I would love to give you 1 minute of concluding remarks, as lawyers always get in court hearings here. The time is running out, and I hope we have, for the audience, addressed really most of the issues that we could in the 1.5 hours. The time just ran really, really quickly. So thank you very much, especially to Barbara, who joined us from far away in the US very early in the morning. And thanks very much to Bruno for taking the time, Thomas and Vivian for joining us today. We have a 15-minute break now, and then we'll continue with session 4, looking at the e-privacy derogation and how to strike the balance between the right to privacy and the protection of children online. That session will start at 5 p.m. Thank you very much.
Thank you very much. Bye.